Thanks so much, Patricia, and thanks everyone for joining us. My name is Sarah Wee. I am CSAJ's Director of Research and Programs, and we are thrilled to have everyone join us today in this first part of our Consumer Rights Training Toolkit on coerced debt, debt defense, and safety for survivors of domestic and sexual violence. I want to give just a couple of notes before we hit the ground running. One, as Patricia said, we are recording today's webinar, and we'll make all materials available on our website after part 2, since we're doing a series. So good news for all of you here. If you've registered for today's training, which you have because you're here, which is great, you don't have to do anything. We'll send you an email directly when we have everything posted, and that will likely be about the first week in July. Number 2, we hope you will join us in 2 weeks for part 2 on June 27th, where we'll all get our hands dirty planning multi-level strategies to address debt and coerced debt facing survivors. So I hope that you're already registered or that this webinar inspires you to join us in a couple weeks. And finally, engage with us. You can tweet with us at CSAJ News, look us up at Facebook, email us at info@csaj.org, and please use the chat box to introduce yourselves, engage with each other, ask questions, engage with the faculty. Those are my little notes, and let's practice that. So I do want to briefly introduce our faculty. While I do that, can you all let us know who you are and where you're coming from? If you could list in the chat your name, organization, maybe where you live and what questions you're bringing with you today, that would be really helpful. And I'll ask our faculty to also introduce yourselves in the chat so folks can recognize your chat handle. So while everybody does that and introduces themselves, we are surrounded by some superstars today, and that includes everyone who's joined us. I don't want to go in too much depth. I want to get right to the content. So instead, take a look in the file pod that Patricia pointed to, and you can check out some bio sheets about each of our faculty. But briefly, I'm thrilled to introduce our faculty, Adrienne Adams, who's an associate professor with Michigan State University, as well as the Research Consortium on Gender-Based Violence there at MSU. Angela Litwin, who's a professor of law at the University of Texas School of Law. Diane Johnston, who's a staff attorney with the Legal Aid Society here in New York City, as well as Katie Vondelinde, who is an expert advisor for CSAJ, as well as adjunct faculty with Washington University Brown School of Social Work. Combined, they are going to take it away and do some amazing work, and really need you to engage with them to do that today. So thank all 4 of you for joining us. And I'd also like to introduce CSAJ's Executive Director, Erica Sussman. She's helping me facilitate discussion, and will work with you all to dig into some of the content today. So Erica, do you want to introduce yourself and help situate us a little bit?
Absolutely. Good afternoon, everybody. Thank you, Sarah, for all of those introductions and for the framing of today's webinar. I am really honored and thrilled to be joined by such a powerful group of faculty who have collectively presented all of their time and energy and thoughtfulness into preparing for today. I am also really humbled and excited by all of you, the participants who are joining us. I'm just looking at the chat box even as I'm speaking, and we have people with such rich and varied expertise from all over the country. And so we are thankful to you all for joining us, and are looking forward to learning from you during the course of the next couple of hours. So I'm going to just quickly talk about CSAJ's mission and vision, and then we can delve into the content of today's program. So the Center for Survivor Agency and Justice is a national organization that has an ambitious vision, which is a world where all people have equal access to physical safety, economic security, and human dignity. And our vision is carried out through our mission statement. The Center for Survivor Agency and Justice promotes advocacy approaches that remove systemic barriers, enhance organizational responses, and improve professional practices to meet the self-defined needs of domestic and sexual violence survivors. And really, it's that 3 different levels of impact approach that is a central part of the way that we engage in this work, and also is an organizing principle for the webinar that we're hosting today. Our faculty will be talking about the issue of coerced debt from these 3 different levels of engagement, and we are very much excited to think across those different levels with all of you.
Wonderful. Thanks so much, Erica.
Okay.
So before I hand it off, go
Sorry.
ahead.
Go ahead. No, I was going to hand it over to, I think, Katie to be talking about today's learning objectives.
Go ahead.
Go ahead, Sarah.
Sorry about that. I'll hop in just to point out a quick note about this. I just want to underscore today's learning objectives and echo what Erica said, that no matter where you sit, we hope that you walk away with some good gems for today. And just very briefly, those gems are that everyone should be able to talk about coerced debt and the range of survivors' lived experiences with it. Also walk away with some concrete examples and tools to support your advocacy. And I just wanted to put a quick note here that you all shared a lot of really rich information when you registered for today's webinar, and there's a lot that we cannot cover in the 2 hours that we've allotted. But if you do look at the file pod that, again, Patricia pointed out, where all the bio sheets are, you'll see 3 chapters from our guidebook that have really good how-tos and practice tips on a range of credit and debt-related issues. And all of our faculty will be talking about those and touching to them, and also referring to the guidebook and other resources for a little bit more. So take a look at those if you have some specific questions. And then finally, we hope you'll also leave equipped with resources and strategies to enhance your advocacy, whether that's legal or in other forms with survivors, and having thought through the issue from an intersectional lens, which is what Katie's really going to kind of guide us throughout the webinar today. So without any further ado on that, I'll hand it off to Adrienne to start us off.
Thanks, Sarah. It is a pleasure to be here with you all today to discuss what is a very important topic, coerced debt. We're going to start out by answering the question, what is coerced debt? The coerced debt is a component of the wider system of power and control that abusive partners use to gain power and control over their intimate partners, right? I'm sure that many of you recognize this framework. It is referred to as the power and control wheel. The wheel illustrates this vast array of tactics that abusive partners use. On the outside of the outer ring, we have physical and sexual violence. And the threat and the act of physical and sexual violence reinforces the tactics that appear in the middle. And these tactics that abusers use regularly include coercion and threats, intimidation, emotional abuse, isolation, minimizing, denying, blaming, using the children against the survivor, using gender privilege. And it also includes economic abuse. And this is the piece where coerced debt primarily fits in. Economic abuse is defined as behaviors that control a person's ability to acquire, use, and maintain economic resources, thus threatening their economic security and potential for self-sufficiency. In an early study that my colleagues and I conducted, we interviewed 103 women seeking services from domestic violence programs. What we found was 100% of them had experienced psychological abuse. 98% of them experienced physical violence. And 99% experienced economic abuse. So the study suggested that economic abuse was just as common in abusive relationships as physical and psychological abuse. And rates of 90 to 100% have been reported elsewhere in studies of women seeking services from domestic violence programs. Before I go on any further, I do want to make a note about language. You're going to hear Angie and I use the pronouns she and her to refer to survivors. This is because the research on which the information that we're presenting was conducted with women. And so basically, violence against women is the social problem that our work has focused on to date. So perpetrators of economic abuse use a wide range of tactics to control their partners. These tactics can be grouped into two categories or types that we refer to as economic restriction and economic exploitation. Economic restriction involves imposing limits on the survivor's economic resources. So this includes tactics to limit the survivor's income, her spending, access to money or property, and financial information. Economic exploitation involves forcibly or fraudulently using a partner's economic resources for one's own advantage. So this can include forcibly establishing a financial arrangement in which the survivor's money is spent on necessities while the abuser's money is spent however they want, or the survivor's money is spent on things for the abuser. It also includes stealing the survivor's money or property for the abusive partner's own use, and creating debt in the survivor's name. And this is what we're here to talk about today, abusive partners creating debt in survivors' names. So I'm going to turn it over to Angie to describe this form of economic exploitation in detail.
Thank you, Adrienne, and thank you all for joining us, and to Sarah and Erica and Patricia for hosting us. I am honored and thrilled to be here as well. So creating debt in survivors' names can happen in a variety of ways financially. There are almost an infinite number of financial products and ways to exploit them. So one category is taking out loans in her name. That could be anything from home mortgages to payday loans to car loans to student loans. Second is taking out or using credit cards in her name. We separate credit cards because there's a different relationship between opening an account and borrowing money than with other types of loans, right? An abusive partner could open an account and either not make purchases or pay them off. So taking out a credit card doesn't always lead to debt. Conversely, an abusive partner could also exploit credit cards that the survivor already has by making purchases for them, for himself on them. Finally, household bills are another way that debt gets created in survivors' names. Things like putting the electricity bills or the lease to the apartment in her name and then not paying or not allowing her to pay them. And all of these types of loans are taken out in two ways. And those are fraud and coercion, right? Those are the two mechanisms. Fraud is using, the key factor there is that the survivor doesn't have knowledge, right? Using the survivor's personal information to take out credit in her name without her knowledge. In our credit system, one of the key gatekeepers, key ways that lenders know that you are you is by you being able to accurately produce your personal information. Guess who else has our personal information, right? Our intimate partners. So that's one way that fraud gets enabled. Another particularly common instance of this is taking out credit cards over the internet. I interviewed a woman whose ex-husband did that and also obtained several vehicle loans in her name using his sister to impersonate her for the car loans. And then coercion is using demands and threats to force the survivor to take on debt she would not have otherwise incurred. So it would be a demand to, say, take out a student loan, and then a threat of some type of abuse if she doesn't do it. We refer to debts incurred by fraud or coercion as coerced debt because they occur in an intimate relationship where one partner uses coercive control to dominate the other. In his pioneering book, Evan Stark described coercive control as the systematic, ongoing use of violence, intimidation, isolation, and control to restrict the survivor's autonomy and liberty. One reason why our research has focused on women with abusive partners is that the coercive control form of domestic violence is highly correlated with men who are abusing women. So the broader context of coercive control enables the abuser to create an environment in which refusing a demand or questioning his behavior is dangerous. And that enables abusers to generate debt in their partner's name through discrete transactions using coercion or fraud. So here's how coercive control plays into this, right? If asked to assume, and we put asked in quotes, sole responsibility for a lease or a utility service, sign for a loan, take out a credit card, or buy an item on credit, the survivor does so or risks harm, some type of abuse. And that would be how a coercive transaction is generated. If the abuser uses her personal information to take out credit in her name without her knowledge, and she suspects or discovers the debt, confronting him or reporting the fraud, as one might do in a non-abusive relationship, means risking harm. So that is one way that coercive control plays into fraudulent transactions. Also, taking control over aspects of the various of one's partner's economic life makes coerced debt much easier to accomplish via fraud. So I will now turn it back to Adrienne, who will discuss what we know about these debts so far.
Thanks, Angie. So I'm going to review our research findings that help answer the question, how common is coerced debt? So recently, Angie and I partnered with the National Domestic Violence Hotline to survey callers about coerced debt. We collected data for an 8-week period, and in that time frame, there were 10,232 callers to the hotline. Of those, 8,033 met our criteria for inclusion in the study. That is, they were female domestic violence survivors over age 18. And of those, 1,863 participated. We dropped 20 of them from the analysis because they were from other countries, and because the U.S. has a different consumer credit system, or consumer credit systems vary across countries. We didn't want to include others from outside the U.S. system, and that left a final sample of 1,823 women with abusive partners. So to give you a sense of who participated in this study, most respondents were between the ages of 25 and 45 years old, and just over half identified as women of color and just under half identified as white. So Angie explained that there are two types of transactions that result in coerced debt. We have coercive transactions and fraudulent transactions. So we looked at both of those. So first, coercive transactions. What we found was that 43% of participants reported that their partner had put debt in their name using coercion. Now, Angie mentioned that coercion involves both a demand and a threat of a consequence for not complying with that demand. So to determine if a transaction was coercive, we asked participants about both. demands and threats of consequences. So women who reported that that their abuser had demanded that they take on a debt, they were asked, what would happen if you said no? And so this graphic shows the types of consequences they face. 63% feared psychological abuse, such as name-calling, yelling, or screaming. 37% feared physical abuse, including being beaten or killed. 8% mentioned fearing economic abuse. So they talked about fearing job, money, or property loss for not complying with the abusive partner's demand. And 22% of the hotline callers reported a fraudulent transaction. So that is 22% found out about debt or a bill that they owed that their abusive partner put in their name without them knowing. Now, of those who experienced fraud, we asked how they discovered the debt. Most found out about it from a creditor. Some of the other ways that they discovered it was by looking at a credit report, applying for services or a loan, being told about the debt by a third party, maybe a relative. Others saw financial statements. For some, the abuser confessed to it, and there were some who found out about it through a collections process or through a divorce process. Of those 63% who learned about the debt from a creditor, so that biggest chunk, 67% of them received a notice via mail, and 24% received a call from the creditor. So that was the results for coercive transactions and for fraudulent transactions. What you're looking at here is the results for either or both types. So what we found was 52% of callers had an abusive partner put debt in their name through fraud or coercion, so through a fraudulent transaction or a coercive transaction. So 52% of the women surveyed on the hotline had coerced debt. Now, 32% had debt that their partner put in their name via fraud or through coercion that involved the threat of physical harm. So here we've excluded those cases in which the threatened consequence was physical or economic. So this only includes cases in which the threatened consequence was physical. And 35% had an abusive partner put debt in their name through fraud or through coercion that would have been considered duress under current U.S. law.
Sorry, can I add one thing there? That is the part of the definition of duress that is undermining a person's free will. Usually people won't qualify for a duress defense because the creditor is a third party who gave value and didn't know about the fraud or duress.
Thanks, Angie. So Angie's original research on coerced debt suggested that abusive partners who generate debt in their partner's name also tend to hide financial information from them. So we asked about this in the survey, and what we found was 71% of the women surveyed said that their partner had kept financial information from them. We also looked at the relationship then between hiding financial information and coerced debt. And what we found was women whose partners hid financial information from them were 3.6 times more likely to have coerced debt. So this suggests that there is a relationship between hiding financial information from one's partner and perpetrating coerced debt. Now remember this finding. I said most women who experienced fraud found out about it from a creditor, and of those, most received the notice via mail. So you might be wondering, how is it that so many women discovered fraud via mail, but their partners are hiding financial information from them? And we had the same question, so we took a look at that. What we found was that a quarter of the women who reported learning of the debt via mail described finding the mail as opposed to directly receiving the mail. So for example, participants mentioned finding bills after a move or a change of address, receiving bills sent to them by mistake, discovering bills when the abuser missed them or when the abuser was away, attaining the mail before the abuser got to it, finding bills in the trash, or receiving bills after the relationship ended. So they're finding the bills despite abusers' attempts to hide them from them. I'm going to turn it back over to Angie to present our findings from this study that tell us something about why coerced debt is a problem.
Yeah, and Adrienne, I'm seeing some questions about duress in the chat. Can we go back to that slide very quickly? I'll just explain a little bit more. So duress is a way to get out of a contract if somebody forced you into it. It's a sort of old doctrine of contract law that if somebody puts a gun to your head and says, here, sign this, you can get out of the contract. The problem is it was really designed for people signing where the person holding the gun to your head is the person you're signing the contract with, not a third party. So I had law student coders look at what would count as duress under the part of the definition that only looks at it undermines your free will. And that broadened physical abuse to include things like reporting someone to the immigration authorities, hurting their pets, et cetera, et cetera. And so that's where we came up with this 35% figure. I'm sure Diane may mention this later, but I just wanted to state that no, it won't hold up in court under duress law because there's an exception for a third party who provides value, which is gives the credit and doesn't know about the coercion. And that is the credit card company. They actually do provide credit. It just goes to the abuser rather than to the survivor. So I hope that's a little more clear. And we can certainly answer more questions on that. Okay, so why is coerced debt a problem? In our study, we asked about 2 potential effects of coerced debt that could have major negative impacts on survivors. First is credit report problems. Nearly half, as you can see, of callers reported that their credit report or score had been hurt by the actions of an abusive partner. An additional 14% said that they were not sure. And in addition, these numbers may be an undercount because if someone was the victim of fraud and did not know about it, they would not have, they would not know that their credit could be damaged. We looked at the correlation between reports of coerced debt and credit damage, and we found that women who reported coerced debt were 5.7 times more likely to have their credit hurt by an abusive partner than those who did not. So there appears to be a very strong relationship there. This is very concerning because credit scores are now used for much more than loans. Right? They can also prevent a person from getting employment, housing, car insurance, basic utilities, or a cell phone. For example, with employment, 60% of employers use credit checks for at least some jobs. And of course, right, jobs, housing, utilities, car insurance, those are the things exactly what a survivor needs to start an independent household. In addition to outright denial, poor credit history can also lead to higher fees for services such as cell phones or insurance and higher deposits for things like utilities. It can end up with a deposit request that's so high that it effectively prevents a survivor from opening utilities. We also asked whether callers had stayed longer in an abusive relationship because of financial concerns, and 73% of callers said yes. This was getting at financial dependence, something we know from other research, which is that women frequently have to stay with abusive partners for financial reasons, right? It becomes one more way of trapping somebody in the relationship. And women who reported coerced debt were 2.5 times more likely to report staying due to financial concerns than those who did not report coerced debt. So there seems to be a strong correlation there. So that is the end of mine and Adrian's presentation. We thought we would stop for a few minutes and ask you all some questions about what you've seen. We're already seeing in the comments that a number of you are seeing this in your the survivors you work with lives. We also wanted to ask about what about survivors with no credit, who are living in poverty, in what other ways might poor credit or debt show up for survivors of color, immigrant survivors, LGBTQ survivors, and at the intersections. And Adrian, if you want to continue with the questions. And
also
in what way,
how you see,
go ahead.
Also how you see credit damage showing up in survivors' lives. If there's some ways that some survivors are differently impacted by this than others. We'd love to hear from you.
Yeah, so just respond in the chat room if you, I don't know if there's a way for me to go back to the chat to look at some, because I know several people posted saying that you see this all the time in your practices or advocacy work.
Yeah, this is Sarah. I'm seeing a lot of folks talking also about the kind of why credit matters and some of the collateral consequences like utilities, housing access, the risk and need for bankruptcy, filing for bankruptcy later, and kind of the compounding impacts of all of that work.
So somebody just posted depleted funds, making it impossible to hire an attorney for custody court. That's a really good point, that financial issues can then extend into issues that are sort of basic survival needs, like being able to keep your children safe. So as well as creating problems in of themselves.
I see questions about what can be done about this, and we're definitely going to get to that later on in the webinar.
Yes, Adrian and I kept our presentation very brief so that you have a lot of time to hear from the people about what to do now.
Yeah, and so feel free to keep asking them questions in the chat about their research or about their work if you need more information, because there's certainly a lot more where that came from. And there's some more interesting comments coming up just about, and this came up during registration as well, folks who are working with survivors who are still with their abusive partner and how to manage credit and debt-related coerced debt concerns. And then, so that's a really important thing to kind of think about, survivors who have no credit and what kind of their options for safety look like, and then moving into how to think about that when we start applying some of these advocacy approaches.
Yeah, it looks like a number of people are posting about clients having no credit, right? That can be equally as much of a problem, right? The converse situation where the abuser prevents the survivor from having any credit in her name, right? That can also make things difficult. And of course, having no credit because of poverty is also a problem as well.
Yeah, and there were a couple of participants that have underscored the disparate impact on immigrant communities as well, and a couple of folks who have echoed the ways in which no credit or poor credit lead to collateral consequences in terms of housing. So that has come up several times.
And one person made a really interesting point, which is that survivors can end up taking out payday loans to cover the coerced debt, and then that gets them to additional debt cycle.
Absolutely.
I've also seen a lot of people talk about the challenges that are coming up in terms of evictions and eviction reports on credit as well.
Yeah, and I'll just note that related to the housing and the bankruptcy and some of those specific examples of the collateral consequences, We will be having additional in-depth webinars on those issues, and our guidebook goes into that in depth as well, which is why this is such a foundational issue, since it kind of touches and overlaps with so many other areas of advocacy. So I think that that's also a good place to kind of segue into Katie, for you to kind of pick up and start and talk about some of these experiences a little bit.
Well, fantastic. Thank you so much for the opportunity to share with you all today. And I want to thank Adrian and Angie for giving us such a deep understanding of coerced debt and how it's impacting survivors. Before Diane Johnson talks later about legal strategies to deal with coerced debt, I'm going to explore with you for a few moments a framework of working with survivors on the issue of coerced debt, as well as some initial advocacy strategies. I also want to acknowledge that, given the time frame that we have today, that this will be just a primer, a kind of overview of these issues, but we have a lot more information in a new publication from the Center for Survivor Agency and Justice, which I'll be referring back to several times during my talk today. But it is the Guidebook on Consumer and Economic Civil Legal Advocacy for Survivors. And the first chapter is on this concept that I'll be talking about, which is survivor-centered advocacy. There's also a chapter on credit reporting and repair, on credit discrimination and predatory lending, and a chapter on debt and debt defense. So you'll find a lot more information on these topics in that guidebook, and I hope that you will take an opportunity to look at that after our time today.
And so all three of those chapters are in that little file pod, so feel free to download them right now. Yeah.
Oh, so that would be really easy for you to access them. That's fantastic. Thank you. So the framework I'm talking about today is survivor-centered debt advocacy, which is really based on this concept and this idea that our best work with survivors and the best outcomes for survivors comes when we work in partnership with the survivors. And this really kind of challenges our ordinary notions or ideas about what we are as advocates or lawyers or technical assistant providers, that we are the expert. And it's flipping this idea to kind of think about, again, the survivor as the expert of their own life, the survivor as the expert of the risks that they are facing, not only the risks based on what their abusive partner might be doing in their life, but also the risks based on their targeted identities that they're exploring, that they're dealing with as well. And also the survivor's expert on knowing what they've tried before and what has worked and what hasn't worked, strategies that they've implemented long before that they've met us and that they're continuing to work through. And so us as the advocate or the lawyer or a technical assistant provider, whatever our role is, what we bring is we bring expertise in remedies and legal processes and information that we can add to and enhance the survivor's information. And what I found in my work is that frequently in the domestic violence world, our concern for survivor safety becomes so big for us that sometimes we become more directed than we really mean to be. And I've really found this a lot in my work doing economic work with survivors, because when we think about the economic realm, most lawyers, financial planners, folks that are working on economics kind of have a strategy. This is how you should do this. This is how you can improve your credit. If you do this, your credit will be better. And that's fairly consistent advice. But when we're working with survivors of intimate partner violence, the advice that is kind of our standard advice may actually put the survivor at greater risk of harm. So we'll talk about later, get more into some of these issues, but thinking about things like how disputing a fraudulent account on a credit report could actually increase risk to a survivor, and thinking about that all the time. We found that if we leave survivors out of the decision-making process, we actually may make them less safe in the long term, because we cannot possibly understand all the survivor strengths, all their concerns, and their different experiences they've had. So survivor-centered advocacy also pays attention to the power we have in the relationship with the survivor. So we ourselves, and I know as an advocate, I've oftentimes not felt very powerful. But when we really explore a relationship with survivors, the survivor sees us as somebody who has information, who has power in our relationship. And so therefore, sometimes when we're not even trying to be directive, but we may be suggesting a strategy, that the survivor puts our experience or our influence higher than their own, and so they might discount their own knowledge of their experiences. So our goal in survivor-centered debt coercion advocacy is that we're trying to increase self-determination for the client, which will then increase their safety so that survivors become included in the decision-making process all along the way. So we actually have some evidence that show that survivors who work with advocates or lawyers who employ survivor-centered models actually have less difficulty obtaining community resources over time. They experience less violence over time. They report higher quality of life and higher levels of social support. They also report fewer depressive symptoms, greater quality of life, and reduced repeat abuse, and increased optimism and internal tools. So survivor-centered advocacy really responds to the broad needs of the survivor, including their physical, emotional, economic needs, their needs around their kids, while also understanding their values, identities, and experiences that influence their safety and their wishes and their strengths. So if we look at the model kind of in front of us, the survivor defined coerced debt advocacy is going to look at the survivor's goals, their values, their identities, and their strengths, while also looking at the broad concept of safety, needs, and risks that are going to them. And then what we have to offer is the credit and debt education that we add on to enhance their own experiences and what's happening for them. So if we are looking at the first circle, really focusing on the survivor's goals, identities, values, and strengths, what we have to do is try to understand what the survivor, when we're starting work on coerced debt, is understanding what does the survivor want to get out of our time together? What value do they see? What are their financial goals? And this is really important because if I'm working with a survivor on coerced debt and what they really want to do is clean up their credit to get a house in 2 years, that's a much different goal, and we might have much different strategies than if I'm working with somebody who really wants to understand why they keep on being denied for getting an apartment and renting an apartment. So understanding people's goals is going to be really important. The other thing that's important that I think we oftentimes really don't focus on is what are the client's values around credit, around debt, around money in general. And oftentimes our own values about money are something we haven't explored really in depth, and so sometimes we may actually be clashing with what the client values, and that may come out for us in being more directive in our advocacy. So, for example, I'm thinking about a client, thinking about clients who I've worked with before when we're working really hard on trying to get money saved away for example, their deposit for an apartment, and kind of thinking about what's happening in their life, and maybe they have a family member that's asked them for money, and they've given that family member that money while they're still trying to save for this deposit. And from the outside, that may look like a decision that we disagree with, but we also might know that for that person in their family or in their community, they may have much more likelihood of getting support from family members around money or community members than from a bank or from other things. So sometimes values within communities are really important to understand when we're working with survivors around money. The other thing that's important for us to understand are what are the targeted identities that the survivor has that may be a challenge as they're trying to have access to different financial institutions, or actually to our organizations as well. Thinking about things like immigration status, thinking about access to banking, thinking about criminal history when we're looking at employment or housing, thinking about racism and how different communities haven't had more of our commercial banking institutions and have had to rely on other forms of commercial access to money. Thinking about language access, maybe folks that identify as LGBTQ+. There may be different issues that are impacting folks' safety beyond their intimate partner that may be part of their equation as they're thinking about coerced debt. And then the other thing that I think is really important to think about as we're working with folks on issues of money in general, but also in coerced debt, are what are their strengths? And how can we build on some of their strengths around money or economic pieces that are going on for them? So want to take a look at, these are just 3 different stories of folks that may be experiencing coerced debt, and thinking about how these different folks' identities may impact some of their experiences. So if we look at Maria, who is an undocumented immigrant who's 28 years old, she speaks some English, but she comes from Ecuador where she was a nurse, but now being in the U.S., undocumented, and not having the credentials to work as a nurse, she's caring for an elderly neighbor, and she lives with her boyfriend, Jim. So if we don't know, but if Jim was using some information from Maria, it may be a different experience than our next survivor we're looking at. So thinking about Lisa. Lisa being a 63-year-old African-American woman who has recently left her a marriage that was 30 years to her partner. And in her time with her partner controlled all the finances. And then even though Lisa had a number of jobs over the years, George continued to sabotage her work experiences. And her spotty work history makes it really hard for her to find work. She's also skeptical. She's never used a bank and is skeptical about using banking. So if we're doing advocacy with Lisa, it may look very different than in our advocacy with Maria. And then finally looking at Jacob, who's a trans man who's leaving their partner, Matthias. And Jacob is kind of thinking about what has happened in his relationship with Matthias. And he helped Matthias out financially, but now he's worried that Matthias may still be using his financial information. And so thinking about if we were going to approach advocacy with these folks, how may their identities impact some of their experiences with coerced debt, some of their experiences with reaching out to different organizations to receive assistance, how it may influence their even opportunities to have access to banking, to employment, and thinking about all of those issues are part of this safety planning, this advocacy work around coerced debt. Just thinking about, maybe some of you can share in the chat if you've had some experiences with survivors with targeted identities that have impacted maybe the advocacy you've done or the focus that they've had within terms of the options they've had and how it's impacted their safety. So kind of thinking about looking back at our model, thinking now we've looked at the survivor's goals, values, identities, and strengths. Now what we're trying to look at also is the survivor's broad safety risks and needs that are happening for them as well within that. So we also have to understand this wide range of risks that the survivors are dealing with from their abusive partner, but also, as I was talking about earlier, their risk inherent to their own life. So for example, when we looked at Lisa's experience of leaving her intimate partner with a spotty employment history, her risk of unemployment may be a larger concern to her at this time than her risk around other parts of her economics. And so we have to kind of focus on what is most important for her as we're doing our work within that. So part of our assessment on how to help with credit is understanding this wide range of risks that clients are dealing with and how the clients themselves are understanding those risks. So really what that takes is asking good open-ended questions about the survivor's risks, their needs, and what they want to get out of our work together. And as I was referring earlier to the guidebook, one place that you can get some ideas for some good questions around this assessment or asking good open-ended questions is from the guidebook, which in every chapter gives us issue spotting questions covering this wide-ranging economic issues that come up for survivors. So some of the questions that you might be wanting to be asking with survivors is what have been your experiences with credit? What are some of your biggest fears when it comes to money? When's the last time you looked at your credit report? How do you think your partner has impacted your credit history? Tell me what concerns you about looking at a credit report. Have you ever been rejected for credit based on your credit report or score? What is your experience in terms of have you ever had a fraud alert or a credit freeze? And trying to understand what's happening for the survivor in that way as well. As we're doing this clear and open kind of assessment about what's happening with credit, we also have to acknowledge that a lot of folks have very intense feelings of shame associated with credit. And there actually may be trauma that's triggered by looking at a credit report or thinking about looking at a credit report. So for example, a client may see, as they're looking at their credit report, may see a line of credit that they know is related to an abusive incident. I had a client I was working with years ago who, when we looked at her credit report, there was a hospital bill based on one of the evenings where she was experiencing a very, very traumatic physical event that really brought back a lot of those feelings of trauma as we were looking at her credit report. Survivors also may have reactions when they're looking at their credit report and they don't recognize a line of credit and they realize that their partner actually was using their account fraudulently, which they hadn't recognized before. So even before kind of thinking about opening a credit report or looking at a credit report, I'm going to ask clients questions like saying something that may be like, sometimes when people look at their credit report, it brings up feelings and memories from their experiences with their partner or with money in general. I'm wondering what are some of your concerns about looking at a credit report? And then you can really work together to reduce the risk if possible, or get the survivor additional support that they need as they are looking at their credit report and thinking about that. The other thing to think about is as survivors are looking at their credit report, my experience is that when they have experienced fraud, they oftentimes feel like it's their fault, that by sharing some personal information with their partner, like their social security number or other information that the abusive partner may have misused fraudulently to open accounts, that the survivor themselves has a lot of feeling like, I shouldn't have done that, it's my fault, I'm a bad person, I brought this on myself. And so I think it's really important for us as advocates to really help survivors understand that in an intimate relationship, we share information with one another, and that there is nothing that person has done wrong, but that the partner is the one that violated the trust. So having all of those conversations, I think, are important even before we talk about kind of what is the process for ordering a credit report. So thinking about the point of when we are trying to think about getting a credit report, why would we want to be doing this? Well, one of the big reasons is because one of the big ways we can assess for what's happening in terms of fraud and coercion is by actually looking at the credit report and understanding what's on the credit report with the survivor. So what this means is pulling the credit report and reviewing it line by line, understanding, kind of seeing what is going on the credit report for the survivor and looking at that. So what are some of the ways that we can pull credit reports? Well, you have this information here from annualcreditreport.com. We can pull the credit reports online. If that doesn't work, and we'll talk about some issues that people have pulling their credit reports online, and also just access technology can be a challenge. But there also is a phone number that you can use to call, and then there also is the opportunity to use a mail-in if you have a lot of time, and that is the safest way for the survivor. So what information do you need in order to get a credit report? You need your name, your date of birth, your social security number, and then addresses. And it is true that you probably do need a social security number. For folks who are not documented, they sometimes can use their individual taxpayer identification number, but that can be rare that there is credit that's kept for them under that. The other thing to recognize is if folks get turned down for a loan because of their credit, that the lender is required to give you a report then, and if they don't, you can ask for it at that time. So that is another option for folks. And also then, especially online, you're going to be going through some security questions. I'm wondering if anybody in the chat has had challenges getting a credit report. I know that a lot of the clients that I've had have a really hard time remembering, and actually when I'm getting my own credit report, I know that there are many questions that I think, did I live at that address 7 years ago? And so realizing that sometimes it may be helpful as we're getting a credit report to try none of the above. That's oftentimes what happens. So they'll say, have you lived at this address? And they'll give you 5 addresses. And so trying none of the above can be a process that's helpful. Another strategy can be to try again with the same or the different bureau. So the federal law gives us access to 1 credit report per year from each of the 3 big credit bureaus, from TransUnion, Equifax, and Experian. So it may be an option to try from another report. I see some people kind of talking about some of the challenges they've had, especially with folks that are transient, and recognizing that the security questions are hard, and it really does freak people out, and it makes it challenging for everybody. So I'm wondering if anybody else have any other things that they'd want to share about how survivors reacted to seeing their credit report, or some of the beliefs about money or finances that has impacted folks. Sarah, are you going to chime in with this as well?
Sure. I'll just point out that some folks have already shared really good tips about how to talk about this, and that there are lots of ways that we can relate to getting new information about our finances, wading into new financial territory, making big purchases, and doing all of that stuff, and just acknowledging even that our society has a lot of norms and taboos and things around finances, and using that as a way to, as Michelle pointed out, that it's not about who the person is, but what they can do with new information. So all of that are really great strategies for kind of addressing some of the challenges survivors have talking about and accessing credit report. But if there are other thoughts about challenges or some of these questions that you see show up, let us know. Shannon's talking about how in rural areas just getting some information on what a credit report is really helpful. So that is great. And if there are other folks from rural areas that have some successful strategies in talking about and accessing credit reports, please share with us. And in a couple of the guidebook chapters that are posted here, there are a few other tips in terms of identifying alternatives to banking and credit, and advocating with banks and credit card companies and different things like that. So those are all helpful strategies that I'd encourage you all to look into in more depth. I can hand it back to you, Katie, but you might be muted.
Oh, looks like Katie may have fallen off just for a minute. She's calling right back.
Oh, okay, great. Angie or Adrian, I know that we were all kind of talking. Do you want to help step in for some of these slides while Katie's calling back in? If not, there's a lot of good discussion too.
Sorry, I was on mute. I didn't realize I was talking and nobody could hear me.
It's not a webinar without that, I say.
Exactly. Yeah, I can step in and do a little bit here. An important safety consideration is that when you pull your credit report, your current address will appear on your report. And so if you're working with a survivor who is trying to hide her current location, that's something to keep in mind and consider an alternative. If you're trying to hide your email address, if a survivor is trying to hide their email address, it can also be beneficial to get one that you use just for getting the credit report, and that can be, a useful practice anyway, to have a separate thing, a separate email address that you're using for these kinds of things that the abuser may not have access to that account, a new account. Similarly, if you're trying to hide your phone number, and get a second phone number for pulling credit reports that has no personal information linked to it. Again, so essentially finding out figuring out ways to have a separate identity that you use for these things, or separate contact information and information like this. And you can get a survivor tender. Yeah, go ahead.
I'll also add that right, abusers have been known to be able to find people when from the information on their credit report. So that's why this is an issue.
Thanks, Angie. Yes. And people can get a free credit report if you're a victim of identity theft. If you've been denied credit, so if you applied for a loan, for example, and you were denied, you get access to a free copy of your credit report. If you're on unemployment and if you're receiving public benefits. And there's information online about how to go about getting your free credit report if you meet any of these criteria. You also might partner with financial institutions in your area to do what's referred to as soft pulls for survivors, which will prevent private information from being added to the report. And I've seen in the chat that some folks have been advocating and building relationships with financial institutions. And I'm looking forward to having a conversation about that in our follow-up, in our second webinar. But I think that is a really important point of advocacy within your community and having these options for survivors.
Another important point about soft pulls is that they don't actually go on somebody's credit report, right? So it doesn't look like the person's shopping for credit and therefore maybe hurt their credit score. Sorry, go ahead.
So how you just let me know, Sarah, when Katie's back on. I can hand it back over to her.
Yeah, will do.
So how do you go about identifying fraud on a credit report? So again, to review, fraud is using someone else's personal information to take out credit. You can do this by gain information about gain their personal information by intercepting the mail, looking at credit card receipts, sometimes security breaches at institutions, employers, and so on can result in people getting their hands on your financial information, your personal information. And in the instance of intimate partner abuse, personal relationships allow access to information. You're sharing a household with somebody or have a close relationship, they're spending time with you, they have access to your information. And what you're looking for is when you're reviewing a credit report for fraud is unidentifiable accounts that the person doesn't recognize. So you want to review the credit report with the survivor, and you're looking for unknown accounts. Examine the dates on the account, determine if the account was sold and has another name. The reason that you want to do this is because oftentimes, sometimes what can happen is an account, an original account is sold off to somebody else, and so it appears on the credit report multiple times. And so somebody might look at that original one and think, I don't know what that is, or they might know what the original one is, but not recognize the institution to which it was sold. Angie, do you want to add anything to that?
Yeah, sometimes you'll see it appear twice on the credit report because it was once from the original creditor and once from the debt collector. And so it's important to link those up so you're not duplicating. And it can also help her figure out whether she, in fact, really knows about this debt or not.
And Adrienne, I'm back.
So, I'll hand it back over to you.
All right. So thank you so much.
Yeah, you're welcome.
Yeah. So thinking about kind of how we do this as Angie's saying, kind of looking at the dates that are happening, but also looking at if the survivor is kind of feeling like, well, I don't know what this is, where this is, kind of talking about what that looks like. So as you're reading the credit report with them saying, this is a revolving account, that means that it was probably a credit card of some kind, that may be that, so kind of helping jog the client's memory. Do they recognize the name of the company? Looking at the dates, is it a collections account? If so, do we know who the original holder of the account was? That kind of exploring that, because my experience oftentimes is especially folks that have experienced a lot of trauma, a lot of moving, a lot of different things, there may be things on their credit report that they don't recognize because they don't, it was theirs, but they don't remember about it. And as we talk through it, they get to it. More oftentimes it is definitely something based on fraud or coercion, but understanding what that looks like is really important as we're assessing to figure out what's going on for folks. Also, because the fraud also is anytime somebody is using the survivor's personal information to open the account without permission or knowledge, and that is also fraud. And so sometimes I think the other thing that happens with our survivors is that sometimes they have family members who may also be fraudulently using their accounts, or other folks in their lives that are fraudulently using your accounts. And so it's oftentimes a very complicated mix as we're looking at folks and trying to understand what is actually happening with their credit and who is using their account without their permission. So, of course, also looking at the inquiry section to see what kind of inquiries were people trying to get debt that they didn't get access to, also for evidence of fraud as well. We're also trying to, as we're reviewing credit reports of folks, looking at this idea of coercion that we talked about earlier, that the coercion is the demand to take on the debt plus a consequence for not complying with that demand. So kind of asking questions that are here, like, did your partner pressure you to open this account? What does that look like? And how did that happen? And then were you worried that your partner might hurt you if you said no, and that this is coercion that folks have experienced within their credit? So we've looked at the aspects of assessing for a client's safety needs and risks, what their goals are, what their values are, what their identities are, and what might be fraud or coercion. So the last piece is really what we do in terms of credit advocacy and trying to figure out what are the pieces that we can help folks with in that. Thinking about, as we do credit advocacy and education, what we're constantly thinking about is how we are presenting the information. So not directive, but kind of sharing and saying, some people have experienced this and they've tried this. I'm wondering how that is going to, or how you think that may be helpful for you or not within your experience. So looking at some of the credit advocacy options, thinking about what folks might be doing, one thing that we might do is as we're reviewing a credit report, thinking about each of these topics. What are the pros and cons of doing this type of advocacy? What are the caveats? What might happen? Thinking about how we're sharing that information in a very clear, thoughtful way with survivors, and constantly remembering how this may be impacted by their values, by their target identities, by their experience of abuse. And thinking that we, as we're understanding that. So, and I'm going to go through a few of these from our list, but we don't have as long as we would like. We have disputing fraudulent charges within credit bureaus. So disputes, we can do those online or through mail, but what that really is doing is asking credit bureaus to research the account to determine if they can find information regarding the validity of the account and that if the account was actually opened by this person. And oftentimes the credit bureaus will do this investigation, and if they can't find documentation, or if they do find signatures that aren't accurate, it may be that they would come off the credit report, or they may do more of an investigation. And they may ask that you file some more information. So thinking about with the client, what are some of the pros and cons of doing this? How do they think this may impact their safety? How do you think their partner might react if they do that as well? So some of these issues. If we could also look at the options of doing things like adding a short-term fraud alert on the credit report, so that if they pull the credit report, that the credit report has something on it that says, please do not extend credit to me unless I am there in person and have an ID attached. So thinking again, even the strategy that may not seem for a lot of people like it may cause harm, remembering if their partner is looking at their credit report, they might be asking them, why did you put this on here? What is this about? And so thinking about even in those strategies that may seem like they wouldn't be harmful, that could come up with a safety issue. So talking with the survivor about what would be some safety strategies to reduce the harm in that. So what we're constantly looking at with our advocacy strategies, and I would really challenge and hope that you would look through the guidebook to get some more really in-depth information about these advocacy strategies, is how do we constantly pay attention to the broad array of safety concerns that the survivor may have? How do you think your partner will react if this happens? Having really detailed, thoughtful, and creative strategies to reduce risk, and possibly even doing some role play with survivors about what this risk may be. So as I was talking about with putting a fraud alert on a credit report. It may be that the survivor decides to tell their partner, I think somebody's been using my credit without my permission, and I was talking to somebody at work and they suggested that I put this fraud alert on. I think that it's going to keep my credit report safer. Maybe you should do the same thing. What do you think that would be like for you to put that on? So trying to put it up that not because I'm worried about you, but I'm worried about other people, about my safety and my how they may be impacting my credit. So thinking about strategies, and this is where I know all of you are really gifted and skilled to think creatively with survivors, and putting those same creative strategies that you're so good at towards coerced debt is really going to help the survivors that you're working with. So thank you so much, and I'm going to turn this over to Diane to talk about the civil legal remedies for coerced debt.
Hi everyone, this is Diane, and we'll jump right in. So we're going to start with just some background on consumer debt collection and the law surrounding consumer debt collection. So the basic life of a debt you can see here. Default is the first stage where a client falls behind. The debt will often go into a round of collections. Maybe the creditor does it in-house themselves, or they may hire an outside debt collection agency to contact the client. At some point, the debt will be charged off. That's usually 180 days for a credit card and 120 for an installment loan. And at some point after charge-off, the creditor may sell it to a debt buyer. They don't always. They have the option of pursuing a lawsuit on their own or selling it to a third party. If it's sold to a debt buyer, it'll usually go through another round of collections, again, either in-house or from an outside organization. But eventually, either the original creditor or the debt buyer will file a lawsuit. If they win that lawsuit, they get what's called a judgment. And with that judgment, they can enforce it against the client's wages, against their bank account, or by putting a lien against a piece of property. And I'm seeing in the questions, can you explain what charge-off means? So charge-off is really an accounting term that banks and creditors use when they've deemed a debt uncollectible. They can write it off their books, but it doesn't mean that the client no longer owes that debt. So a lot of my clients see that on a credit report and think that it means that they no longer owe that. Unfortunately, they do still owe that debt, even if it's been charged off. Some quick exceptions I just wanted to list here to point them out. Government debts, secured debts, and any kind of service-based debts have different processes for collecting from clients. So exclude those from how we're thinking about this. And some of the debt collection rules. So the Federal Fair Debt Collection Practices Act governs how debt collectors interact with debtors. There's a 1-year statute of limitations for a consumer to bring a case against a creditor, against a debt collection agency. There are only certain parties that are considered debt collectors under this law. So a collection law firm is considered a debt collector, debt buyers who are third parties buying these debts, and debt collection agencies who are hired by the original creditor to contact the consumer. Under the FDCPA, they're prohibited from any kind of abusive, deceptive, or unfair tactics. So they can't misrepresent the character or nature or the amount of the debt. They also have to verify the debt if requested. So they have to send a certain type of notice that has specific language in it, giving the consumer notice of the debt, and the consumer has 30 days to request verification. If the consumer does request that verification, the collector has to pause all debt collection activity until they provide additional information to verify that debt. There's also rules governing how often and when they can call. So collectors are allowed to call during reasonable hours. They can only contact third parties to confirm contact information of the consumer. So they can't contact a neighbor or a family member just to ask them about the debt or if the client's going to pay. One important thing for domestic violence survivors who are married is that spouses are included in the definition of consumer. So a debt collector can contact the spouse with all the same information and requests as they contact the consumer themselves. They can contact the consumer at work until the consumer requests that they don't, and they have to stop contacting the consumer if requested. So we often send cease contact letters when clients are really overwhelmed with a lot of debt collection calls. There's a limit of 2 times a week if the consumer picks up and verifies that the contact information is correct. So that can often provide some relief for clients who have a couple of debts that are contacting them a lot. If they have many different accounts that they're receiving debt collection calls on, it's not going to provide them as much relief. Other things that they can't say: they can't harass debtors, they can't use bad language, they can't lie, pretend that they're someone that they aren't. We sometimes see letters that look like they're on government letterhead. That's illegal. They're not allowed to try to misrepresent who they are or what their remedies are. And they have to always state that they're trying to collect a debt. So for anyone who's advocated with creditors on behalf of one of your clients, you're probably familiar with that phrase that they always add, that the conversation is recorded and it's an attempt to collect the debt. Okay, so what happens when your client gets sued? And I'm curious if you could add in the chat if anyone has actually represented a client in a debt collection lawsuit. Okay, great. So a debt collection is a state court process, so it's going to differ depending on where you are. The collection firms bring huge numbers of cases against defendants who are usually representing themselves. I work for the Legal Aid Society. We have very few consumer attorneys, unfortunately. It's not a highly funded area for legal services in general. So often a lot of these clients are in court on their own without an attorney. There are lots of bad industry practices in debt collection and in the debt buying industry. And while they're harmful for our clients and make it easier for them to get judgments, they can also create defenses, which we'll go over in a bit more detail. The basic timeline is laid out for you here. So the summons and complaint is filed with the court first by the creditor. They then have to serve it on the client. So they have to provide it to them according to the state law. The client should file an answer, which asserts any of their defenses and puts them into the case. And then there will be a series of hearings, and depending on your state, that may work a bit differently. Here in New York, if the client is not represented, the court's going to schedule regular hearings until they set a trial date. If the defendant is represented, then the 2 attorneys will do discovery and motion practice and won't really go back to court unless there's a motion on or it's being scheduled for trial. And some tips for what your clients can do if they're sued. So if you're not an attorney, if you're not someone who is able to represent your client in that court process, some kind of pointers for you. First advice is not to ignore court papers. Here in New York, if you don't file an answer, the creditor can proceed and get a default judgment against that client without ever having a court date. So we see a lot of people who come to us once they find out that there's a judgment against them. They never had an opportunity to go to court, and maybe they knew about the case or they didn't, but because they didn't file an answer, they never got that day in court. Clients should review the court file and the complaint. The complaint will lay out what the creditor is claiming that they owe and for what, usually. It should tell you the original creditor if it's a debt buyer that's bringing the lawsuit, but it doesn't always. The second thing is to gather documents. So domestic violence survivors often, they've moved frequently, they may be in shelter, they may not have documents, but to the extent that they do, try to bring any of that together. Anything that's stored electronically, if they do have access to account statements where it's not identity theft, and they can pull those or they can provide any kind of proof of payment. If they've disputed any debts, those can be really critical in these cases. So they should keep a copy of any of those disputes and bring them with them. And demand proof. So, even where the client thinks that they actually owe this debt, the creditor is the party that's starting the lawsuit. They have the burden of proving their case. So, I generally think our clients should not readily admit that they owe something. They should make the creditor prove it. So the standard claims that we see in debt collection lawsuits are breach of contract and account stated. Breach of contract is the most common. The creditor has to show proof that there was a contract, proof of any sales or transfers. If there's a debt buyer suing, they have to show every change of hands. Proper foundation for anything that they're using to prove their case, and authority to charge all fees. So not just these cases always include fees and interest that's accrued on these debts. So it's not just what your client actually charged on a card, but all of these other fees. So they have to show a basis for why they're asking for the exact amount that they're requesting. An account stated claim is this, I think, terrible claim where the basis is that the creditor and the consumer had some kind of pre-existing relationship. The creditor sent statements to the consumer, and the consumer retained those statements without objection within a reasonable time. So the creditor has to show that there was some kind of relationship between them. I can't just start sending statements to someone and say, now you owe me this. They also have to prove that there's a basis for any of the fees or interest that they're charging, or there's some kind of agreement as to what those fees or charges were going to be. And this is where a dispute can be particularly important, right? So they have to prove that the consumer kept those statements without objecting. So any kind of written dispute, any kind of testimony about a dispute can be really helpful in overcoming these claims. And I just included some of the states that allow this claim. Not all states do. And I'm seeing someone saying that there's been some cases in dicta saying that accounts stated aren't appropriate for credit card debt. That's great. I don't think we've had anything like that in New York, and they are pretty standard here. So that's good to hear that courts are at least coming around, even if it's not an actual holding in a case. Okay, so some of the common defenses, these are not necessarily specific to domestic violence survivors and coerced debt, but some of the more common ones. First is personal jurisdiction. If the client wasn't served with the papers in the appropriate way, we've had rampant what we call sewer service here in New York, where process servers were not even attempting to give consumers the paperwork to allow them the opportunity to fight the case. Statute of limitations, we see a lot of cases, particularly by debt buyers, being brought after their time to sue has expired. Standing, again, in particular with debt buyers, they have to prove that they own the debt and they have a right to sue on the debt. And there are some claim-specific defenses there as well for car loans, for medical debt, and for rental arrears cases. Specific to coerced debt and domestic violence survivors, identity theft is a common defense, and we'll talk a little bit more about that. Disputed debt, if the client has disputed it in any way because it was coerced or because it was the result of identity theft. And we'll go through that a bit more. Okay, so addressing fraudulent transactions. So if we go back to the earlier definitions that we discussed, fraud versus coercion. So a fraudulent transaction is when the abuser has used the survivor's personal information to take out credit in his or her name without their knowledge. So the law distinguishes between coerced debt that the survivor was aware of and that which the survivor was not aware of. And just a sample definition of identity theft. And I wanted to highlight here that it's when somebody knowingly and with intent to defraud uses the identity of another person by using their personal identifying information, among other things, and thereby obtaining goods, services, or using credit. among other things. So identity theft is frequently committed by somebody that the identity theft victim knows. In the case of domestic violence survivors, that's often the abusive partner. And survivors often get pushback and are led to believe that a spouse can use their identifying information. You'll see in this definition there's no exception for a spouse, there's no exception for an intimate partner or a family member. So just to be clear, there really isn't a reason why an intimate partner is allowed to use someone's identifying information without their explicit permission. Okay, so some case examples. So an original creditor sues Lisa for a credit card debt that she doesn't recognize. She never applied for, received, or utilized the card in question. The original creditor provides account statements showing purchases made on the card dating back about a year. Her abusive ex-partner controlled the finances and restricted her access to mail while they were together, so this is the first time she's seeing these statements. So just kind of an example of how identity theft might play out and what you might be hearing from a client. I wanted to provide one other case example. So after fleeing his abusive partner, Jacob notices a large charge on his credit card. He calls the provider and is told that the charge was made with an authorized user's card in the name of his ex-partner. He says he never requested to add an authorized user, but the credit card company insists that he requested it a month prior, and they claim they verified all of Jacob's identifying information over the phone before issuing the card. So, going back to what we talked about in the first half of the webinar, intimate partners are well positioned to commit identity theft. You know all of your partner's identifying information, past addresses, social security number, date of birth, all of the typical things that a creditor is looking for when they're opening a new account. I think in particular with phone transactions, like requesting an authorized user card, there are additional issues where the creditor can't identify the voice or the person's name as male or female. So particularly in same-sex relationships, and particularly for clients with non-Western names, I see that a lot where some kind of transaction happened over the phone and the creditor insists that they did everything correctly, and we suspect that it's because they weren't tipped off by a voice sounding male or female to them. What can you do? So documentation is really difficult with intimate partner identity theft. Under the Fair Credit Reporting Act, there's a specific definition of what qualifies as an identity theft report that's listed for you here. So the person submitting the report must be subject to penalties for providing false information. It has to be an official, valid report that's filed with a law enforcement agency. These reports can be really difficult to obtain. So what is a law enforcement report? Usually people think immediately of a police report. Here we're often unable to get police reports for identity theft. I don't know if other people experience similar issues in your location, but it's caused us to kind of think creatively about how we can get an official law enforcement report. So the FTC has stated that their full report qualifies as an identity theft report. It's filled out online and you submit it directly to the agency and you get a report number. Some other alternatives that we've explored are using the U.S. Postal Inspection Service report or the FBI Internet Crimes report. Other advocates have also reported using reports to a local district attorney. And so these are just options for trying to get the documentation you need that you can use with a creditor, that you can use with a credit reporting agency. Someone earlier also mentioned safety concerns with trying to pursue a charge of identity theft. Some of these alternate reports may also be good avenues for that. So if your client doesn't want to involve law enforcement and open an investigation or get a case started, the FTC identity theft report may be a good option if it's accepted by the creditor, because that won't necessarily initiate an investigation in a case. Other useful documentation that you can include with your dispute or as a defense is documentation showing that that the parties are no longer together or that there was domestic violence, an order of protection, a judgment of divorce, and looking in those documents to see if economic abuse is addressed. Here in New York, we have financial family offenses, so a domestic violence survivor can include claims of identity theft or coercion in their order of protection. Those can be really useful in the consumer context. If the judgment of divorce discusses economic abuse in the equitable distribution or otherwise, that can be useful. Any proof of disputes, and any way that you can use these documents to demonstrate a compelling timeline. So in one example, I had a client who left the abuser and obtained an order of protection shortly thereafter. Charges were made on her credit card about 6 months later to an authorized card that was sent to the former address. So we had this kind of nice documentation showing, she left the home on this date. We had documentation from a domestic violence shelter that she was residing in, showing the date of her entry to the domestic violence shelter, and then the authorized user card had been sent to the old address several months later. So it was kind of helped us to explain this was actually identity theft, even though the creditor thought that they verified all of the information they were required to. And this is more for your reference in terms of making disputes under the Fair Credit Reporting Act, what that procedure looks like, and the options of getting a credit block. And the key here, I think, is to always ask for details and documentation from the investigation. They'll often do a pretty cursory review and come back and say, yes, everything was verified, this isn't fraud. You want to get more details about what documents did they look at, how did they determine that there was not fraud, if that is their finding, so that you can challenge that specifically. Okay. So under the Truth in Lending Act and the Fair Credit Billing Act, there's something called unauthorized use. So this is use of a credit card by a person other than the cardholder who does not have actual, implied, or apparent authority for use and from which the cardholder receives no benefit. So we're going to kind of parse through these definitions. So it includes a transaction initiated by a person who has obtained the credit card from the consumer or otherwise initiated the transaction through fraud or robbery. And an accepted card is one that the cardholder requested and received or has signed and used or authorized another to use for purpose of obtaining money, property, labor, or services on credit. So this kind of lays out the parameters of unauthorized use and how identity theft fits into that. Procedure here is laid out for you. The liability is capped. But it is a very short timeline. The dispute must be made within 60 days of the charge appearing on a bill. And if you're looking at this in the context of debt defense and how you can use discovery creatively in that case, some of the things that you want to ask for and take a really careful look at. The original application. A lot of these applications are done online, so you want to see what information was entered. Did the client sign anything? Do they claim that the client signed anything? Particularly for store cards, usually there will be a signature page on that application. You want to ask for the signed contract. This is more common with a loan than with a credit card, but again, you want to look at what information was entered, look at the signature if it's there. You also want to look at the dates. I often ask for contracts and get back, my client's being sued on an account that they claim was opened in 2012. I ask for the contract. They give me back something that's dated 2016. So you know that contract was printed out later, not when my client allegedly initially opened the account. You want to look at the address, phone number, and email used. So if your client has moved, or if they were still with their abusive partner at the time that the account was opened, look at what phone number and email address was listed. Were the statements going to another email address that the abusive partner used but that your client didn't have access to? Balance transfer details. This is something I often ask for when there is a balance transfer. Where did that money go? How did it come in? Any linked accounts, you want to try to get more information about those. Purchasing patterns. If you see that there's a gym membership, if there's a way that you can get documents from the gym to show that your client was never a member. Just looking at, if there are purchases made out of state that correspond with times that the abusive ex-partner was out of state or was in that location, but your client was not. And any signed receipts, if you're able to get those. The creditors are often not willing to give these, but anything that you can get with signatures that you can look at and try to dispute whether it was your client that actually signed that. So you want to think about, what documents your client might have access to and things that could help prove that your client is not the one who opened this account or used the account. And one note is just to remember that this process can be really difficult for your client, and reviewing these kinds of details can be triggering. If you're looking through statements that you got from a creditor on an account that was created by identity theft that your client, had no knowledge of, seeing where the abusive partner was spending their money, what they were doing, just the fact of having this debt in their name, is another violation, it's another form of abuse, and so just to be cognizant that this can be a really difficult process for your clients. And I'm seeing in there the question, can you subpoena the call record? That's certainly something that we do. I have yet to get a client or a creditor who's provided that. We're usually able to settle cases prior to them providing that, but that's definitely something that you can ask for. And another question of whether we ever try to implead the abuser. In my experience, that's not something my clients have wanted to do. I think it's certainly an option, but it is something to think about. Often I find that when clients are ready to address financials, it's often when they've been removed from the relationship for a bit longer, they're a little more on their feet, maybe they haven't had contact with their abuser in quite some time, and so the idea of bringing an abuser back into their lives through a court process is not always attractive to them. But I think that that's certainly a potential remedy if that's something that the client wants and is comfortable with. Any other questions through now? I know we've covered quite a bit. Okay. So now we're going to go into coercive transactions. So these are transactions, as we stated earlier, where the survivor knows about the debt or knows about the transaction, but didn't, was coerced into making that transaction. These are harder. The law is not really where we want to be where we want it to be in terms of recognizing this type of debt and this type of coercion, but we're going to explore some potential options. So we touched on duress earlier, and as Angie said, duress arguments will usually fail because the creditor was not the entity creating the duress. So I included here the definition of duress by threat, which is an improper threat that leaves the victim or the survivor with no reasonable alternative. But there's an exception if the assent is induced by a third party to the transaction who made the transaction in good faith and without reason to know of the duress. They gave value or materially relied on the transaction. So this is a situation where the client is under duress by their abusive partner to take out a credit card, to take out a loan, to make some kind of transaction. And the party that's providing the value or providing that loan or credit card doesn't have any reason to know about the duress. So it's really looking at very specific facts and whether your facts can support that. Again, this kind of argument can require a lot of detail about the abuse, so you want to make sure that your client's prepared for that and ready to discuss that and potentially discuss it a lot if you're going forward with this kind of an argument. Okay, so here's a case scenario. Jim is frequently violent with Maria and threatens to report her to immigration when she doesn't do what he wants her to do. He wants Maria to purchase a car for him in her name, explaining that she should because her credit is better. He promises it will be affordable and he will make the payments. At the dealership, he decides he wants a far more expensive car, and while the dealer is reviewing the documents with them, Maria hesitates. He forcefully squeezes her arm under the table and tells her to just sign the documents. She resists again, and Jim whispers in her ear that if she doesn't do this for him, he'll make sure she regrets it. She's shaken, and she signs the documents. Okay, so kind of walking through the definition of duress, is there a sufficient basis for an improper threat? Right, so here he's saying that he'll make sure that she regrets it. We know that there's a history of threats and domestic violence. So I would say there probably is a sufficient basis here. Does she have a reasonable alternative? I think generally we would say no, she doesn't have a reasonable alternative based on the history between them and based on his actions here. But the key question is really, did the dealer have reason to know of the duress? And I'm interested in what you all think if you want to weigh in on the chat. And I personally think, I think this case scenario is the closest that people are likely to get to something that would qualify. I think it's far less likely that an abusive partner is, explicitly violent or, actually violent in front of another party, forcing them to make a transaction. These threats, when they're in public, are often a little more under the table or a little less explicit or less noticeable to a third party.
Yeah, and that seems to be what folks are saying, that it kind of depends on if the dealer was paying attention or how obvious the interaction was.
Mm-hmm. And so I think, this might be a scenario where you have an argument about it. I think, it could kind of go either way. And people are saying, would the dealer even notice? I think that does depend on, is the dealer across the table from them, reviewing the contract? Is the dealer in the back room putting together papers? How obvious is it? How explicit is it? What would we expect the dealer to actually notice? And as Andrew's noting, usually there is more distance between the creditor and the coercion, so which is why these duress arguments are extremely difficult, because normally you're opening a card online, on the phone. The creditor is not actually in the room with the survivor and the abusive partner. Okay. Another argument is making some parallels to innocent spouse relief in the tax context. So the IRS provides relief when a spouse has improperly reported income on a joint return. Usually a spouse who has actual knowledge or reason to know doesn't qualify. But there's an exception for domestic violence survivors who show that they've experienced intimate partner abuse before signing the return and that the abuse caused them to refrain from challenging a tax return. Again, this goes back to the duress argument, and in the context, they've carved out specific relief for this kind of situation. I think there's some interesting case law. I included a quote here from a case before this was written into the law that kind of talks about how duress manifests, how a history of abuse between partners can lead to duress, even if it's not in that exact moment of the transaction. And I think there's some arguments to be made. I think that these arguments are a bit are perhaps better used when you're trying to negotiate with a creditor and you're trying to say, you should dismiss this case or you should settle this case for a low amount. This is what my client went through. I don't think the law is quite there in terms of making this argument in a motion, but it's one route to explore. Okay, so looking again at unauthorized use under TILA. So one of the keys here is that the card is used by a person other than the cardholder who doesn't have actual, implied, or apparent authority. These are state law definitions, so they are going to vary. But implied authority is generally that the principal, so the cardholder's words or conduct, lead the other person to lead the agent to believe that he or she has authority. So you can show authority by the cardholder's acquiescence to the acts of the other party, and the plaintiff has the burden to prove that implied authority was given. Apparent authority is words or conduct by the cardholder that convey to a third party that the agent has authority. So essentially, words or conduct in our context of the survivor that convey to the third party, a creditor, that the abusive partner has authority to use that card. And the third party, like a creditor, reasonably relied on the representations of the abusive partner because of the conduct or words of the survivor. So short case scenario. Juan forces his partner to open a card in her name for his use. When he uses it for a large purchase without her present, he tells the cashier it's his wife's card and he can sign for her. So does he have implied authority to use the card? So did his wife do anything to lead him to believe that he has authority to use her card? I see, Sarah, no, you don't. Does he have apparent authority? So this is where the third party gets involved. So has his wife done anything to convey to the cashier that Juan has authority to use this card? No, right? She's not there. So she hasn't done anything to indicate to the cashier or to any third party that he has authority to use this. And last, so did the cashier reasonably rely on the words and conduct of Juan or of his partner? Right? So she's not there. So here they're relying on him saying, it's my wife's card, I can sign for her, not on the wife actually saying, it's fine for him to use this card. So this is an example of how you could make the argument that this is unauthorized use. So, even if they're in a spousal relationship, we see a lot of partners sign for each other. That's not really something that the third-party creditor or cashier, whoever is doing that transaction for them, can rely on just the one party representing that they have authority. And the second part of this definition is that it includes a transaction initiated by a person who has obtained the card from the consumer or otherwise initiated the transaction through fraud or robbery. So here you're trying to look at, do your facts look like a theft at all? Can you, is there a way to frame this as a theft or as a robbery? And did the survivor do anything to revoke authority? So even if the survivor opened this card or added the abusive partner as an authorized party, did they do anything to try to scale that back? For a scenario here, Anna tells you that her abusive partner is particularly violent after drinking. One evening, she comes home to find him extremely drunk, and he immediately starts berating her. He rummages through her purse, finds her credit card, and turns toward the door. Anna doesn't object because she's afraid he will hurt her. So, is this identity theft? Okay, not until he tries to use it. Kelvin saying yes. I don't think it is. He's not pretending to be her. So again, this is where gender comes in. If this is a same-sex relationship, that partner may more easily be able to use that card, pretend that they actually are their partner. The second question, is it unauthorized use? So based on this definition that we have above, where they've obtained credit or initiated a transaction through fraud or robbery, what do we think? Could be, he'll have to say that she gave him permission or impersonate her. Yeah, I think there's an argument here that, maybe it's not identity theft, but I think it more closely falls into that definition of unauthorized use. Okay, and just a word on using these arguments. So I think some of the most effective ways to use it, pre-litigation advocacy. So sometimes the creditor isn't willing to absolve the consumer of liability, but they may agree to cease collection efforts. And just having that conversation with the creditor, letting them know that the survivor has an advocate, can sometimes dissuade a collection case. If they think, okay, if we sue this person, they already have an advocate, they're already making these arguments before we file the case, this is going to be a more difficult case for us to win. You can use this as an affirmative defense to a debt collection case, whether it's identity theft or trying to use some of these coerced debt arguments, depending on your facts and depending on whether the client has disputed those debts. In pleading the abusive partner, which somebody asked about earlier, again, I think this is, in my experience, this is often disfavored by clients. Usually when we're addressing their debts, any kind of custody, order of protection, those cases have kind of resolved. They may have a divorce that's ongoing, which they may feel like, if I'm already having to see my abusive ex-partner, what's one more case? But I find generally with my clients, they don't want to bring their abusive partner into a case. They want to deal with it and move on. A declaratory judgment is a strategy that I have not used but was shared by a colleague with another organization, essentially asking the court to declare a debt to be the result of identity theft. So this is a strategy that could in particular be used when you've had a lot of back and forth with the creditor, you've done some disputes, they're not acknowledging that it's identity theft, they're not acknowledging that it's fraud, and the client wants to dispose of the debt instead of sitting back and waiting for the creditor to sue them. This is one way to get the debt in court and try to get a resolution on it. Other affirmative litigation based on unauthorized use or based on some of these other claims. Again, this isn't something we normally pursue in my office. We're usually doing more of the defense work, and I think that raising these claims can be easier when you're in a defensive situation, because often we find that creditors, once we raise them, they don't want to get into litigating these issues. They don't want to make bad law. We don't either. So we're often able to resolve it frequently without our client paying anything on the debt. But there's certainly pros and cons of these strategies in terms of taking proactive steps versus waiting for the creditor to do something. Pre-litigation advocacy, I think, can be really effective and really helpful and can prevent a lawsuit from happening. But you really want to talk through and think through with your client. What does your client want out of your work with them? Why are they coming to you? Do they want to fight this case? Do they want to settle it? Do they just want to move on from it? And how can your work best reach those goals? So whether it's just to get it done with as quickly as possible, or to get some kind of resolution out of it that they feel, they feel like they need a specific type of resolution to feel empowered. Also think about, will your strategy pose safety concerns? So again, pleading an abusive partner could cause safety concerns for your client. You want to think those through carefully before you file anything that will cause your client to interface with their ex-abusive partner. And lastly, will your strategy potentially create bad law? So we always want to get decisions where, you know, we're moving the law forward in the direction that we want to see it go. But is there a potential that your strategy could do the opposite, and you could create some bad law that's going to hurt survivors in the future? So we covered a lot here. Do people have questions? We'd like to bring this back to thinking about intersectional considerations. Have you seen this play out with your clients? Any strategies that you'd like to share?
Wow, yeah, this is Sarah, just echoing, that was a lot and amazing, Diane. Do folks have more questions? Or I also like the idea of sharing some successful or innovative strategies that you've all used. As we spend our last 5 minutes kind of wrapping up, let us know what's on your mind. And I'd invite Adrian, Katie, and Angie back as well, maybe while folks are sharing, thinking of some final questions or things to share. If you all have final thoughts or questions for our audience here, that might be a good way to kind of wrap up.
I'm wondering if anyone would be interested in sharing some of the new learnings for them today, and maybe some ideas of how you might engage in some of these things that you've learned.
It also looks like a lot of people are typing.
Yeah, some live evaluation. What's new? What didn't you know that you now know? Or what's affirming?
I think that another thing that I've learned from doing economic work, especially around credit and debt, is that I learned by doing it, and so sometimes taking that first step, reading the chapters and working with survivors, it seems daunting, but you can learn so much throughout the process, and using expert advisors that are around CSAJ, we're happy to help as you come up with challenges or issues that come up for you as you're doing this work.
Yeah, that's a great point, that the way we here at CSAJ think of these webinars is that this isn't sort of a one-off thing where we just unload everything that we know on you and that's it, but it's really the starting place. So please do reach out and let us know how this is showing up for you, and how we could be kind of supportive and connect you either with folks on this call or other folks that we work with or maybe have done similar work. So that's a really great point, Katie. So just some kind of practical questions that are coming up about certification and CLEs. Yes, we'll send a follow-up email with a certificate of attendance, and you'll receive that directly from us, so just keep an eye out in your inboxes for that. We do not at this point offer CLE, but we do provide all the information that you will need to submit it to your own board. So if you need extra support with that, just let us know if you don't have everything you need when we send all the follow-up material. So we have a couple of announcements and things that I want to make, but I want to give our faculty, again, maybe a final reflection or opportunity to share a reflection or question. So Adrian, Angie, Diane, if you have any final thoughts before we close up.
just thank you to Katie and Diane for such a terrific presentation about what we can do about it, right? That was really helpful. And it's nice to have places to go and not just hear the bad news from Adrienne and I.
We did all that, Angie. Thanks.
The context and the critical questions that you two lay out are really helpful, and I know that there are a lot of folks from state coalitions and doing policy work and providing their own TA, so understanding on a broad level how coerced debt shows up and what we might be able to do about it is really important as well. And we'll be digging into that more in 2 weeks, so make sure you join us for that. So Katie, you want to give the final little pitch about that, and I'll do other announcements as we invite people to leave and go about their days?
Absolutely. We're very excited about our next webinar. It's going to be part 2 of the Coerced Debt webinar in 2 weeks on Wednesday, June 27th, and this is really going to be new for us. It is actually a workshop type of webinar. It's going to be really creating partnership for system change. So the first part of that webinar will be Diane actually sharing about the work that she's done with DV So each time we do these webinar series, we'll have somebody sharing innovative partnership work that they're doing to address the issue. So Dan will share about some of the work that they're doing around debt with the DV project, and then each of us will get a chance to break out into 3 different breakout groups that will be associated with the interest that you have. So if you are interested in thinking about coerced debt and thinking about the needs that you have in your own community around coerced debt and coming up with some ideas around that, you can go into that workshop, or you can also choose to go into a partnership mapping workshop. So thinking about who are your partners around coerced debt, who could you start engaging with, who are other people around the country engaging with, and how that might work. That's another option. And then the final option is if you want to think about strategic action planning and working on a systems level change. So we're really excited about it. Each of these workshops will have a worksheet that you'll complete, so you'll have a tool as you walk away to start doing this work within your organization in a different way. We also will have access to all of the tools that we're using, so that even if you choose one of the workshop breakout sessions, you can see the other tools. We'll come back together as a group and review the work that we've done, so everybody will be able to learn from the opportunities that people have had in their small group work to share back together. So we're really excited for this opportunity. If you're interested in coerced debt and wanting to dig deeper within your own community, within your own organization, this is the place for you. And it doesn't matter if you've never done work on coerced debt before or if you've been doing it for 5 years. I promise that there will be something that you can get out of this workshop, and you will have some tools to take with you back to your organization. So we really are looking forward to this opportunity, and many of the staff that are here today will be back on that call in 2 weeks. And we just really hope that you'll consider joining us and inviting other folks within your community to do the same.
Yeah, thanks so much, Katie, and thanks to all. I think Angie just said it in the chat that it will really be kind of an extension of the amazing work and thinking that was taking place in the chat today. And we really need all of you to be able to do this. So, and in order to do that, I'm going to copy into the chat right now a link to our evaluation form. The only way we can place you in a room is if you let us know what you're most interested in. So make sure you let us know your feedback about today and how we can support your work, as well as letting us know kind of what you're interested in participating in that webinar in a couple of weeks. So
Sarah, somebody asked about how they register. Oh, never mind.
Oh, perfect. Thank you. Yes, you can go to our website. The same registration form that you filled out for today's webinar is the same registration form for June 27th. So you can just go back and I believe you select the dates that you want to attend. But if that doesn't work, we can also just let us know, and you can also contact us at info@csaj.org, and we can provide you all that information. And when we follow up with the certificate of attendance and just follow-up materials for today, we'll share the registration link and all of that stuff as well. So it should kind of fall right into your hands. So I'm going to very quickly go through some of the other things we have going on. If you want to stick around to hear about these resources and ways that we want to engage with you, please do. Otherwise, deep and sincere thanks to our faculty, to Adrienne, to Angie, to Katie, and Diane for sharing your work and engaging with our experts in the field, who are all of you who have attended today. So thank you all so much, and thanks to all of our attendees. We look forward to working with you much, much more in the future. So as folks sort of hop off, I just want to go through a couple of things. Katie noted that in 2 weeks we're highlighting the work that Diane and her colleagues and partners are doing here in New York City. We're also interested in hearing what you are doing. If you have some innovative work on consumer justice, economic justice that you're doing, please let us know. We're trying to feature spotlights throughout the next couple of years in the phase of this work, and also have a better understanding of what is it that folks are doing across the country, and how can we share that and do some exchange. So please take a look at that link and let us know what you're up to. Katie was talking about full and open assessment, and the guidebook goes into that really specifically. We also have some tried and true resources that really help ask some internal reflective questions, both for you as practitioners in the field as well as for your organizations, and what it takes to engage in this advocacy. So I'd suggest you take a look at our resource and assessment tool, as well as our guidebook. You can download the chapters here. You can also go on our website to take a look at those. And here are a couple of core resources that we like to share. CSAJ conducted a needs assessment that talks about partnership, and this is from back in 2012, and it's a great way of examining and thinking about how you all engage in partnerships and approach consumer advocacy. And we have some resources on the economic ripple effect of domestic violence, and tools that are useful in your systems advocacy and to fuel the work that you're doing, as well as a pilot site report that really distills how it is that folks are going about this work, where they are, and again, that assessment tool. We have a full resource library, so please check it out. And this is the tool that we've been talking about all day, the guidebook. Please check it out and let us know how you use it and what would be helpful going forward. And related to this, we'll release very soon our full webinar calendar, which will include things like how to address economic relief, including tax, addressing tax issues in the context of family law, looking at bankruptcy and student loan advocacy, examining how barriers to housing and employment, things like that are all coming up over the next couple of years, so please join us for all of that. We also have an Accounting for Economic Security Atlas, which really distills this paradigm for survivor-centered and multi-level intersectional advocacy, and talks about shifting from a framework of self-sufficiency to one of economic agency, and what's required of us all as advocates, regardless of where we sit in the movement, to work towards this. And finally, in another project that we do, we just released a report from our Racial and Economic Equity for Survivors project. We talked about a lot of intersectional considerations and how identity and marginalization shows up and really has a profound and disparate impact on survivors who are marginalized. And this report really talks about how advocates, attorneys, coalitions, programs can really sit with and identify and adjust the way that we do the work that is reflective of ideals around race equity. So also check that out. So with that, again, take our evaluation form. We are nerds over here, and we like to know what you think and respond to what you think, and they're very important, and we need those to really engage you the best way that we know how in the next webinar and to inform all of our work to come. So thank you all so much for sharing and for being here. Thanks again to all of our faculty, and we'll see you in a couple of weeks. Take very good care.